What?
Hello?
Hello?
Hey there. I'm just letting folks into the room here and then we'll take attendance.
Okay.
Someone is on two devices at once and they need to make one go away.
So hang up the phone and you use this one. Okay.
Your Honor?
And then we'll take attendance.
I can't hear.
All right. Give me 1 second. We'll clear this up.
Raise the volume. There you go.
Okay.
Your Honor, this is the court reporter. I have a request for you, if it's possible for you as the host to record this meeting so that you can send me the WAV file later. And the reason I say that, it's been my experience that sometimes certain people, depending if they're on a cell phone or on a landline, will either drop or they will sound like they're underwater on my end. And so when I go back to clean up the transcript, there's going to be a lot of inaudibles, you know, unless I have that original clean recording by Zoom.
Can I have your name?
My name is Marcy Kale, M-A-R-S-I. The last name is spelled K-O-E-H-L, and it's pronounced like the vegetable kale.
Got it. All right, Ms. Kale. I'll press the record button in a minute when we are rolling, and we'll see what happens here. You are taking a step beyond my technical prowess. I'm able to get the live feed going. So we're actually live on YouTube right now. It's a 10-second delay, but I've confirmed that it's going. So there's that. But I also see the record button. And once I call the case and we figure out who all is here and folks tell me they're ready to go, I'll hit the record button. What I don't know is where that goes and how to get that to you. But there are people I know who I can talk to that may be able to help with that. Does that work?
Okay. That sounds great. And then I just need to know how I touch base with your office, I guess, and so we can coordinate how they can email that to me. And sure, I can help.
That will be through Ms. Niles, who is my staff attorney. And you can reach out to her via email, and she may not be the one who provides the recording to you. Again, that will likely be our technical folks who would know where this thing that we're recording is saved.
Yeah, whoever set it up has that authority to go in there, and it's either going to be saved to the Zoom cloud or it's going to save to your actual computer. So it just depends on what they decided when they set this up.
Yeah, my guess is it's going to the cloud. Otherwise, our computers would pop. But
got it.
We'll see what happens. But thanks for asking that. All right, let me figure out who we've got here. First of all, this should be folks who are on for the case 2019cv321908, which is Mr. Hurd versus Mr. Collie. I am in courtroom 1D, which is open to the public, and I'm here to let you all know that Mr. Collie is here. He is sitting in the gallery. He can't see you, but he will be able to hear you. He can see me and he can hear me. But he is physically present for the hearing. Mr. Hurd, I believe, is represented by Mr. Kane. Is that correct, Mr. Kane?
Yes, sir, that's correct.
Okay, so you're on our screen as Danette Yazid, but I recognize you. You're Daniel Kane. So we've got Mr. Kane here. And I think Mr. Collie is represented by Attorney Moore. You're the gentleman in the yellow tie?
Yes, sir. Yes, Your Honor.
Your lawyer looks very good today. All right, I'll let Mr. Collie know you dressed for it. All right, he's in some fancy office. You must be paying him a lot. I can see like some skyline in the background.
You're too kind.
All right, so that is Mr. Moore. And then it looks like Ms. Kale has two. I just need to figure out who's on the screen. Ms. Kale has two tiles on the screen. Ms. Kale, you are phone number 4869.
Yes, that's me, and it's probably because I'm using a landline versus using my computer or anything.
Okay, that's fine. You're welcome to be on both ways, but I see there's a tile with your name on it. There's also a phone That's 4869. And then Ms. Niles, my staff attorney, is on. That is all good. So I will endeavor to record as we start, and we'll see what happens. As I said, there's also a YouTube feed. Query whether that'll be helpful for you or not. I think we're able to archive that on the county end of things, but I'm going to hit record, and hopefully that doesn't blow things up. Record in the cloud. It is connecting, and as far as I know, it's going. So we will take it from here. This is a dispute over a piece of property on Metropolitan Parkway. I don't know if that's a house or a bowling alley, which you can open up on Friday, I'm told, or something else. But there is a convoluted history, as best I can tell from reading through the pleadings, as to the dynamics of the contractual relationship between Mr. Hurd and Mr. Collie. We are here today not to resolve the case, but because there are motions for summary judgment. And I don't know if the two attorneys have spoken as to who wants to go first. I guess I'm prepared to listen to everything you've got to say. I would like you to headline it by why you think there are not material issues of fact that require this to go to a fact finder, whether in the end that's me at a bench trial or a jury, whenever we can next get a jury in place. Because I'll tell you, my reading of the pleadings is that there are very different versions of events that are not resolved simply by looking at the quitclaim deed or the purchase for sale agreement. There are human elements to it that will require, I think, people testifying and some fact finder assessing their credibility, because people are providing very different and conflicting recitations of what was intended, what was meant, what really occurred, and what the goal was of the transaction. So we can get down into the nitty gritty, but I don't know that that's merited by what strikes me as an outside observer, some pretty hefty factual issues that the fact finder in the end would need to work through. So with that preface, and the knowledge that I understand a whole lot less about the dynamics of the land transaction that the two parties entered into, I'm happy to open it up as whatever way you want. Before you decide that, there was one document I needed to sign, and the officer has just come in. So we're going to pause real briefly. I'll pause the recording. I'm going to sign this document, and we'll be back on. Don't go anywhere. I am unmuting, and I am going to start the recording again. Oops, cancel, resume. There we go. All right, all that was probably captured on the YouTube live feed for public consumption, but that just makes things more viewer friendly. Ms. Kale, have you been able to hear so far?
Yes, sir, I have.
Great. All right, Mr. Kane, as counsel for plaintiff, do you have a preference as to who dives into this first?
Yes, sir. I filed the first motion for summary judgment, so I would like to go forward.
All right, Mr. Moore, any issue with that?
Full deference to Mr. Kane,
He
please.
gives it the thumbs up. All right, Mr. Kane, why don't you please get us started?
Okay. So I understand that the court has reviewed the pleadings in this case, and the court's of the initial assumption that there's a contradiction factually into what each party says. And I understand that that's not the, well, that is the test for denying motion for summary judgment. I understand the court's reading, and I reviewed it in my head, the conflict in the testimony several times. And I think I can make this very simple for the court if we go back to fundamental and basic contract law. So I'd just like to address some fundamental contract law principles and then address the facts of the case.
Okay.
This contract, well, let me give you, first of all, the history of the contracts. There is a March 27, 2017 lease called the first lease, which is exhibit number 1. And that's been attached to my motion for summary judgment. That lease has a special stipulation where it states in the future that the lessee, Mr. Collie, intends to purchase the property. It has a purchase price, and it states that he will pay $96,000 non-refundable earnest money. Okay? That's March 27, 2017. The next document is an April 25th, 2017 quitclaim deed. That's exhibit 2. The next document is a May 17th, 2017. That's the second lease. Are you still with me?
I am, and I excuse me, I have all the exhibits
Yes.
because you all provided them in advance.
Yes.
So I've got exhibits 1 through, well, for plaintiff, it's 1 through 4.
Yes. Okay. The fourth exhibit is the May 17th, 2017 commercial purchase and sale agreement. And that's the issue which we are litigating here today.
Okay, is it, tell me, when you say it's the issue, and maybe that's why you're saying we need to return to contract fundamentals, I'm thinking just as one example, the quitclaim deed. There are very different descriptions of the purpose and the intent and the meaning of the quitclaim deed that don't seem susceptible to resolution by applying legal principles as opposed to weighing the evidence and the credibility of the folks who are talking about it. But maybe when you're talking about the PSA, you're going to explain why the quitclaim deed is really a side rabbit hole that we don't need to get into because it can be resolved through the PSA.
Well, yes, I would characterize it as a rabbit hole we do need to get into that will be resolved by the PSA.
Okay.
So the chronology is a quitclaim deed is entered into on April 25th, 2017. Now, we maintain there's no consideration for that. And so now we have this contract, May 17, 2017, which is the same date as the second lease, May 17, 2017.
So the $96,000 in earnest money, it would be mistaken to construe any of that as consideration for the quitclaim deed.
No, it would be accurate to consider it as a non-refundable deposit for the purchase and sale agreement, which is how it's spelled out in the commercial purchase and sale agreement. It's also addressed in each of the leases as a non-refundable down payment or earnest money.
Do any of exhibits 1, 3, or 4, so 2 leases and the PSA, do any of them refer to the quitclaim deed?
No, and now you're getting to the fundamental contract law.
Okay.
So let me just do it fundamentally so we don't have to get into what the he said and Collie said and Hurd said. This purchase and sale agreement, it's commercial property, by the way. So large down payments are not unusual in commercial transactions.
Yeah, what is at 834, if that's the right number?
It's not
Metropolitan Parkway. What's there?
It's a service garage. It's a garage that was used as a body shop, and Mr. Collie used it as a mechanical shop.
Okay.
So that's what it is. So it's a commercial piece of property subject to a commercial purchase and sale agreement dated May 17, 2017. Now, what the court is obligated to do is to review the contract to determine whether there is an integration clause. And in this specific contract, there is an integration clause.
When you say this specific, you mean the May 17th PSA?
Yes, sir.
Okay.
There is an integration clause. And that is called, that's in paragraph C3 small c. It's called the entire agreement. So this is not in all contracts, but it is in this one. And it's a fundamental contractual provision that says basically, which we remember from law school, you got to look at the four corners. But what these integration clauses are, if it's not in the four corners, it isn't real.
I'm just looking at C3C. I see the entire agreement. Okay. Yep. That looks like fairly boilerplate, not in the sense that it's ineffectual, but that looks like a standard entire agreement or integration clause. Okay.
Okay. So we have this integration clause, which says you've got to go by the terms of the contract. Okay. So the terms of the contract are very specific. The terms of the contract require a down payment, $96,000. The terms of the contract say the $96,000 is non-refundable. The terms of the contract have a closing date. The terms of the contract have a purchase price. That's all in the contract. So what the court's obligation is to follow the law as outlined by the Court of Appeals and the Supreme Court on these integration clauses. And there's, I sent you a supplemental brief, but it basically says the cardinal rule of contract construction is to ascertain the intentions of the parties. The construction of the contract is a matter of law for the court. You see, now that takes us out of the factual argument. So it's a matter of law for the court to construct this contract. The court must consider whether the language is clear and unambiguous, and the court is obligated to enforce the contract according to its clear terms and to look alone to the contract for its meaning. And I cited the case, I can give it to you. It's Alimenta versus Oilseed South, 276 Georgia Appeals at 62.
Okay.
Okay, so here's where we are. We've got this purchase and sale agreement. First of all, we got Collie getting a quitclaim deed dated April 25th, 2017, which he doesn't pay for. He doesn't pay the $385,000 for the property. He doesn't have a closing. He's got, when we say basically swindled or tricked Milton Hurd to give him this quitclaim deed so that he would hold it, quote unquote, to make sure Hurd doesn't sell the property to somebody else. The contract requires a closing. The contract requires a closing date. The contract requires a specific amount, $385,000. And the contract requires Hurd to convey a limited warranty deed. Okay, so none of that.
Did Hurd convey the limited warranty deed?
No, and this is the problem. There was never a closing.
And was there never a closing because the Bootery wouldn't get the payoff letter from Bayview? And that was, I mean, I'm wondering if there are nonetheless facts that make the failure to close something that a fact finder has to work through. I followed you along. I'm not disagreeing with what you said so far, but I flagged the quitclaim deed as but one example of what seemed to me to be a series of factual disputes as to why the transaction didn't go through. And maybe you were going to get there, but I understand that there is a dispute about why the closing didn't happen.
Well, let me answer that question. And this is because Collie says, and I put it in my brief, Collie says that by paying the $96,000, the deal was consummated and the closing was no longer necessary. That's his position under oath. He says that by paying $96,000 non-refundable earnest money, he received title to the property. He says that the commercial purchase and sale agreement was null and void in that it was superseded by the lease, which doesn't make any sense.
Well, Mr. Collie, I don't know, he is sitting here, but I assume he's not a lawyer. And so his answers to questions like that might be interesting, but aren't necessarily dispositive as to whether something was null and void or not.
Well, okay, I'll agree in principle with that, but he does say no closing was necessary because I paid $96,000 non-refundable earnest money.
Okay.
But you're asking about the bootery and the letter from the lender not being signed. That's just a ruse. There's no closing scheduled. There's no written notice of closing as required by the contract. Again, the integration clause, the four corners. There's no closing attorney. Herd's never given notice. So all of these things, if there was really a closing, and Herd said, if you get a loan, I'll sign the payoff letter, which you don't really need because Collie had it anyway. You get a loan, you get a closing, I'll sit down and I'll sign the documents. But that never happened because Collie took the position he didn't need a closing. And he admits that he never paid the purchase price, the $385,000, because he maintained that a closing was no longer necessary. So my argument to your honor is if you just look at the four corners of the contract, you're going to see that nowhere in the contract does it say Collie gets a quitclaim deed, that Collie gets title to the property by virtue of if he gets of a quitclaim deed, that if Collie pays the $96,000, no closing is necessary and he gets title to the property. None of that is in the contract. That's all make-believe hocus pocus because he breached the contract and wouldn't vacate the property, which we gave him notice to vacate and he wouldn't.
So the part though that's not make-believe or hocus pocus is a quitclaim deed that your client signed over to Mr. Collie and it's been recorded. How do you make that reality square with the four corners of the contract? I appreciate that the PSA with its integration clause may be the agreement between the written agreement between Mr. Herd and Mr. Collie that controls concerning 934 Metropolitan Parkway. But there's also a quitclaim deed out there. And I don't think that you have, and maybe you're going to get to that, but it doesn't sound like it was the product of duress. It seems to have been part of the negotiations that went on between Mr. Herd and Mr. Collie.
Okay, so that's an alternative theory. We say that Collie scammed or tricked Herd by misrepresenting, just give me this deed, I won't file it until the closing. And I'm basically trying to provide the court with a legal avenue to grant summary judgment rather than go through all the facts. Herd, and we put this in our brief, in our initial brief, that Herd maintains that he was told that Collie asked for this deed, that Collie had it prepared, that he asked Herd to sign it, that he wouldn't file it until the closing, and he just wants him to hold it to make sure Herd won't sell the property to somebody else. Collie then basically went down to the courthouse a couple months later and filed it without any notice to anybody. And this is important, no consideration. There's no consideration to support it. So you can look at that as an integration issue. The contract says you must pay money, but you didn't pay it.
Okay. So tell me, just so I can understand how the situation developed, Mr. Hurd, as the owner, was facing foreclosure on the property.
That's correct. Repeatedly.
Okay, it has nothing to do with Mr. Collie, at least initially. Mr. Hurd, for whatever reason, wasn't able to pay his mortgage, and he was facing foreclosure. At some point, Mr. Collie appears on the picture, and the foreclosure crisis is averted. And at that point, does Mr. Hurd let Mr. Collie occupy the property, or had Mr. Collie always been a tenant there, or what? Tell me that. How did that play out?
So there's two parts to that question. The first is, the property was not in foreclosure. Hurd was he was delinquent on his payments.
Right. As I understood, foreclosure was pending, not that it had been foreclosed upon, but the creditors were banging at the door.
Well, the creditor was Bayview, and Hurd had always been late on his payments, and he was deeply in debt at this point. But it wasn't in foreclosure, and there was no notice of foreclosure. So that's the first part.
Okay.
The second part is Collie came. Hurd was going to sell the property. Collie came as a prospective purchaser and entered into that March 27, 2017 first lease, where in the special stipulations, he states he intends to purchase the property in the future. And it sets out the $96,000 non-refundable earnest money, and it sets out a purchase price. So after that first lease, Collie is entitled to occupy the property, which he does. And then that's where it gets a little jiggy. Collie comes up and says, I have this option in the lease to buy it, sign this quitclaim deed, and I won't file it. So you don't sell it out from anybody else, which Hurd does. And then you have the subsequent, the May 17th new lease, which is similar to the first lease, and then the May 17th purchase and sale agreement.
Your Honor, I don't mean to interject, and I'm all deferential to each side going, to the extent an objection is appropriate. We've made a number of statements of record, Mr. Collie, but we haven't pointed any authority. Is there something that we can use, or would you like me to just take my notes and, rebut those things when it's my turn? Because some things are being put out here to fit a narrative, and I don't think there's citation to authority on that.
Understood. No, what I would prefer, given the format we have, is that you scribble furiously, make notes as to what you want to share, and you'll be given a full opportunity to not only attempt to rebut what Mr. Kane is saying, but also present your perspective.
Thank you so
Normally, if we were live in court, everyone present, it would be easier for you to rise and say, there's something I think it's important for you to understand at this juncture. But here it's, I think, easier in particular for Ms. Kale if we have one person handle his presentation and then the other side.
Perfectly fine, Your Honor. Thank you.
Okay. Back to you, Mr. Kane.
All right, I'm not sure where we are. Did you have a question?
Well, you had explained why you thought the quitclaim wasn't pertinent to working through the four corners of the May 17th purchase and sale agreement.
I think respectfully, I think it is pertinent, because I think if you do the analysis of an integration clause, there's nothing in the PSA about a quitclaim deed. See, Collie's whole argument is, and I cited it in my brief with specificity, that by paying the $96,000, I get a quitclaim deed and a closing is no longer necessary. That's not in the contract. That's make-believe. So we can go into a fraud, he said, or you can just look at the four corners and say, Mr. Collie, it says you pay $96,000 for a closing on a date certain in the future. It says nothing about you get title to the property by paying the non-refundable earnest money. And
so the earnest money, by adding that adjective, you answered my question. There's not then a scenario where if the closing doesn't go through, that the $96,000 goes back to Mr. Collie?
It's non-refundable. The majority of it went to catch up the mortgage, and the balance went to Mr. Hurd as earnest money.
Okay, and Mr. Collie was paying rent to Mr. Hurd while he occupied it?
Yes, the lease, both leases have a set amount, and basically the lease rental payment was the mortgage payment.
Okay, so it was enough to cover what was owed to Bayview on a periodic basis?
Yes.
And why were there two leases so close in time?
I don't know. Collie was generating documents and bringing them to Mr. Hurd. And Mr. Hurd, so the dates are pertinent. When Hurd, after signing the May 17th, 2017 lease and the May 17th, 2017 purchase and sale agreement, Collie was generating more documents to Hurd. And in June, when Hurd found out that Collie had filed the quitclaim deed, Hurd said, I'm not signing any more of your documents. You have to get them through a lawyer. You've scammed me out of the property with this lease. You got to set it aside. And so I don't know why, to answer your question, I don't know why Collie kept generating these documents.
Okay. All right, anything else you want to share, or you want to have Mr. Moore go for a little while, and then when he's finished, you'll have a chance to respond?
Yeah, I'll say one more thing. Let's see. So I'll just leave you with this, and this is in Collie's deposition, page 50, line 1 through 4. Collie maintained that by paying the non-refundable earnest money, $96,000, the deal was consummated and that closing was no longer necessary. So if that's his position and he doesn't schedule a closing, all this talk about the Bayview loan letter and the bootery doesn't make any difference, because he had no intentions of closing the property, because he's maintaining to the world a closing is no longer necessary. I have title to the property, which is just in complete contradiction to the contract, applying the integration clause in the four corners.
Does an integration clause, the way I understand it, and I'm not a contracts expert, the integration clause would be a way to cause the court to not worry about the terms of the first or the second lease, but I'm not familiar with an integration clause having the power of, we need to disregard a quitclaim deed. A quitclaim deed is of much more significant impact on title and ownership than a lease agreement. So I guess I'm circling back to why you think there aren't two set factual narratives that we need to work through. One of which may well be, it is a question for the court. What does the PSA say? What does it mean? And what is its effect? And as you point out, and that's pretty standard law, the construction of the contract is a matter for the court to work through. And that's pretty standard for summary judgment. But I don't know that that makes the quitclaim deed go away. And so it may be that you would be entitled to summary judgment on some of the counts of the complaint, but I don't know that the integration clause makes the quitclaim deed go away. And if you are then getting to your counts about fraud and whatnot, then I think we do have a he said scenario that isn't susceptible to resolution in this setting.
I understand the court's analysis, and I would state two things. The first is there is a failure of consideration, which is a basic contract principle. Mm-hmm. A non-refundable deposit, non-refundable earnest money, is not consideration for a quitclaim deed. The second is, if you apply the integration clause, which is the intention of the parties, it's not mentioned. And the integration clause is after the quitclaim deed. There's no mention whatsoever of a quitclaim deed, and there's no consideration for it.
Okay. So and I'll need to review my property law. The quitclaim deed itself, it always helps to look at the documents, says that the grantor, your client, for and in consideration of the sum of $1 and any other valuable consideration in hand, paid at or before, blah, blah, blah. That's pretty standard language in quitclaim deeds. It's a buck. Now, you may be in a position to prove that Mr. Collie never handed that $1 bill to Mr. Hurd, but the quitclaim deed doesn't say, oh, by the way, the $96,000, that was the consideration for this quitclaim deed. And I flag that not to take a position contrary to Mr. Hurd ought to win on the merits in this case, but to point out that I just, you need to carry me further along the lines of no consideration for the quitclaim deed. You've helped me understand that at least in none of the 3 legal agreements or written agreements, lease 1, lease 2, or PSA, is there language that says, oh, part of the back and forth here is part of what's being exchanged for value is the quitclaim deed. The 3 documents are silent as to that. But I don't know that the quitclaim deed can be just brushed away because no one at this point can put their hands on yet another document. It would be document 5 that says, here's the dollar I gave Mr. Hurd for the quitclaim deed. And I'm not trying to be overly technical. That's how these things often work. An aunt to her nephew quitclaims it, and it's for consideration of $1. And no one ever gave $1. It's just, this is what they decided to do. They end up in front of me because aunt said, no, I didn't do that. And my nephew said, if I sign this, he'll help with my mortgage. And the next thing I know, he's evicted me from my place. But that gets to a fact finder as opposed to a motion for summary judgment.
I think I can clarify that.
Okay.
And I think the court is going down the trail that I went down originally, like facts or law. Mm-hmm. So going back to the contract and the integration clause, and then the testimony of Mr. Collie about consideration, which is what the court is raising for the quitclaim deed. And the court's doing a technical analysis of the 4 corners of the quitclaim deed and using what's kind of generic language, $1, another good and valuable consideration. You don't have to, you can look at that, but what you really look at is Collie's testimony. And Collie's testimony is that by virtue of paying $96,000 non-refundable earnest money, the property would be deeded over to him. So Collie maintains the consideration is the $96,000 non-refundable earnest money. If you look at the 4 corners of the contract, that is not correct. Collie also says that by paying the $96,000 non-refundable earnest money, the deal was consummated and the closing was no longer necessary. So Collie's stating incorrectly, factually and legally, that the earnest money of $96,000 meant he got title and a closing was no longer necessary. Collie didn't want to close the property because Collie had a quitclaim deed and he thought by trick or device that gave him title, which it didn't.
Because going through the closing would require Mr. Collie to put more money down. The property was worth, I don't remember the number, but near $400,000. So there was a gap between $96,000 and whatever the closing would be.
Yeah. So Collie maintained, this is not hocus pocus, maniocus. This is Collie saying, I don't need a closing. Closing's no longer necessary. I paid $96,000 and I got title to the property. But that's not what the 4 corners of the contract says. And that's why I keep drawing the court back to the integration of the contract.
Okay. You do keep doing that. That's correct. All right. Let me hear from Mr. Moore. I'm sorry. Keep going.
Yeah. Collie can say anything he wants, but it's just not in the contract. You know, they can do all this bootery and save you and he wouldn't sign this. It doesn't matter. It's not in the contract. Okay. So I surrender the floor.
Thank you for doing that graciously. And Mr. Moore, thank you for abiding by while Mr. Kane was presenting what he wanted to present. I know you have a competing motion. I think a lot of this sort of merges. So if there are points you want to make that are distinct to your motion, I'd ask that you make them second, because right now I'm dialed in on what I just heard Mr. Kane say.
Absolutely.
There you go. Excellent. Hopefully there's some
On
overlap.
that, Your Honor.
Hold on just a second. Your Honor, with Mr. Moore's audio, he's sounding underwater, so I don't know if he's on
I haven't
his...
really given him a chance to talk yet. So let's
Well,
let him say
earlier
a few
when he was
things, and
talking.
then if it's still an issue, we'll work on the technical aspect.
Thank you.
Go for it.
Okay.
All right, sorry about that. And yeah, please let me know if I sound underwater. I'm not, I promise you. So obviously I'm going to take exception with what, much of what Mr. Kane said in his recitation of a transaction that I think he would find convenient on his facts as pled. I did find it somewhat astounding that his alternative theory was that of fraud when his complaint is completely rife with contentions of fraud. But that this afternoon, really the crux of his argument is this tenuous application of the integration clause. I don't need to learn the court on the integration clause. I can just tell you that your perception, Your Honor, of having sort of a bicameral transaction is actually exactly what happened. So we have an avenue that is inclusive of the quitclaim. We have an avenue that's inclusive of the PSA. I want to address, again, I'm not going to contend anything on the integration clause. I categorically disagree and would, in the event you would permit, Your Honor, would love to brief that. That arrived yesterday afternoon and did not have time in preparation of this today to brief on that. However, let's talk, I think, precedingly, would you like me to go through the facts as we perceive, Your Honor? Would you prefer me to go on what plaintiff's contentions are here and talk through those?
Well, I'll say this. I'm aware that there is a divergent set of facts that comes out of the pleadings from both sides. And so I'm familiar with those. I guess what I'd ask you to do is if you think that summary judgment shouldn't be granted to plaintiff, you ought to tell me why. And in doing so, you'll probably weave into that. One reason would be that Mr. Hurd said, and here's his deposition, and he said, I give you this quitclaim deed in exchange for $96,000. I'm making that up, but there may be facts that you want to weave into your disagreement with Mr. Kane's arguments that I think will frankly highlight my opening perspective, which is that there's just a whole lot of factual disputes here that may not, we'll see, be susceptible to legal resolution at this juncture.
Very good. I appreciate that. And with that, so let's just go through this case in a nutshell. So taking it from the top, plaintiff contends in his brief, and this is extrapolated from his brief on which we're arguing right now, that number one, the quitclaim deed should have never been filed. We have two avenues of facts here. Number one is the position that my client has taken and is on record. The second is what the plaintiff contends happened. In either case, there's no factual support whatsoever. So those two are this. Taking the facts, since we've already heard them presented to the court by plaintiff's counsel, is that the deed was supposed to be held by my client until closing. That sounds like a condition precedent. That the quitclaim deed, in effect, should have been held in escrow upon the closing of, let's just call it, the transaction. Well, as I provided to the court in the Dodson v. Pope case, you cannot escrow a deed with a condition precedent from the grantor to the grantee in the state of Georgia. Abundantly clear. And there's there's even more case support cited in that case that propounds those very principles. So on that fact, if I even took for granted that the facts were as plaintiff contends, that fails right off.
Well, maybe. Let's assume for a minute that after hearing the facts, the fact finder decides, you know what really happened here is that Hurd said, sure, I'll sign the quit claim. I understand you want a show of good faith. You're giving me almost $100,000 and you want something to raise your comfort level. So here's a quit claim deed, which means basically I am deeding you the property, but don't go file that. I know enough about property, this would be Mr. Hurd speaking, that you shouldn't file it because then it would appear to the rest of the world that you own this place, which you don't yet. All you're doing is leasing it, and we're envisioning a way where you may have ultimately buy it. So please hold on to it. And Mr. Collie says, okay, I'll do that. But he doesn't. He actually goes and files it. I don't know that the way the law would work is that those facts would be untrue just because that's legally improper. I didn't know what you just told me was the case, that you cannot escrow. I don't know that most people know what it means to escrow a deed, but you cannot escrow a deed that has a condition precedent, that you're not supposed to do that. I don't mean to say that's a crime, but I don't know that we're dealing with parties with the level of real estate law sophistication that one would know, I'm going to get him to agree to escrow this deed on a condition precedent, and then he's in trouble for doing that. So tell me why it still couldn't be that Mr. Hurd thought that was a reasonable request by Mr. Collie, but the security he wanted for the quitclaim deed was put it in a file cabinet. Don't do anything with it until we close on the matter.
Correct. And thank you, Your Honor. And you're right. And again, that's very perceptive. So, again, and we have on record that there was no representation during this transaction. So there are some, features of it that any, qualified practitioner would have avoided or done differently. So I do take that for granted. But that being said, the situation looked like this. So we had the property in 934, the subject property was pending foreclosure, which was learned by defendant upon inquiry into the sale of that property. Mr. Collie had seen it, had liked it, had felt that it was going to be great for his shop, and reached out to the broker. It was listed, and wanted to engage in in a normal purchase and sale transaction. I think as you took note, some of the some of the facts were, I think, a little bit mucked up a little bit by the that was with an M, Your Honor, by virtue of this foreclosure. Okay. Now, during this sort of back and forth and negotiation on the purchase of this property, the property was in fact in foreclosure. Mr. Hurd is on his deposition says that it was in foreclosure. In fact, in a couple of different places. So he's very much on record indicating that yes, it had precedingly been in foreclosure and that it was currently in foreclosure. In fact, to the extent that the foreclosure date was actually submitted by Bayview Loan Processing. All right. Now, to that end, time became more of the essence. Now, as that can be, contracted around in a, with a heading and gender of time of the essence, it truly was in this sense because they had to do their best to survive this foreclosure date by bringing it current. Enter the money that was paid. We'll talk about the effect of non-refundable and earnest in a moment, but $96,000 was purported to be the consideration for the equity that Mr. Hurd had in the property. The reason that it determined to be at or about $100,000 was that there was an existing obvious mortgage, the one that was in foreclosure. So one can presume that there was a lien on this property for the amount owed under that principal mortgage. So Mr. Collie says, well, what we can do is bring it out of foreclosure. I can remit an additional, which was the first $36,000 payment. I can remit an additional $60,000 payment. And then we will work to refinance the remainder of it out of your name. And that at the relinquishment of the $96,000, there was the mutual dependent covenant to provide the quitclaim, because in effect, the interest of equity that Mr. Hurd had in the property was relinquished at that point. The recital of $1 was captured by the 96K. So
Okay, that's helpful to understand. Is any of that in a written agreement between Mr. Hurd and Mr. Collie?
No.
To my knowledge, that in and of itself is on. We have Mr. Collie's deposition to that effect, but a writing, I do not believe we do.
Okay, and if I were to,
other than the deed itself, I'm sorry, other than the deed itself, which can be dispositive in the recitals there, you can condition, you can put covenants, etc., in that deed that acts in effect as a contract.
but the details of what you just described, that 96,000 reflects Mr. Hurd's equity in the property, and so a $96,000 total payment, 36 to bring the mortgage current, and then 60 to pay the rest of the equity that Mr. Hurd enjoyed in the property, and that would get Mr. Collie the quitclaim deed. The way you know that is because people have said that in a deposition, as opposed to an exhibit you could share.
That is correct.
Okay, and if I were to dive deep into Mr. Hurd's deposition, would he confirm that there was an initial understanding as to what the $96,000 was all about? Or is that a factual disagreement? Collie and Hurd tell different versions of events.
Correct. So somewhat, impliedly, absolutely. Is there an express, hi, I am giving you this quitclaim deed and you are giving me this, right? We don't, and oftentimes in these cases, as you are well aware, that is not the case. So no, we don't have that express line item, but we do have the admission that all of that money was provided before the quitclaim for the quitclaim, with Hurd's admission on that.
Okay.
Okay.
Yep.
So we also have that. We also have some very conflicting testimony between the statements made by Mr. Hurd, and I find them highly concerning. And as we have delved into some of these facts, I do want to point to the court that Mr. Hurd very clearly and demonstrably doesn't recall the timeline of events that we have before us relative to this entire transaction, written documents, oral representations, and things of that nature. We have an iteration that the quitclaim deed was not signed before the PSA, which was false, because then later in his deposition, he says, no, I did receive the earnest money before the quitclaim. He was aware of the quitclaim. He provided and delivered the quitclaim, and he was granted the $96,000. He admitted that there was improvements to the property. So just to point out one overarching point while I'm on the discussion of his deposition, again, plaintiff's complaint and the claims on which is predicated a summary judgment, again, completely and entirely in this concept of fraud. I went and reviewed the glossary of terms, Your Honor, in the deposition. The word fraud was used 0 times. The word lie, 0 times. The word false or false pretenses, 0 times. The quitclaim deed was very much addressed, at which point I believe if the whole contention of your case is that it's predicated on fraud, where are these communications that contended that things weren't, that things were misrepresented and there was this fraud? And furthermore, if we're making the claim that there was a quitclaim, even irrespective of whether it was recorded or not, and if it was, and I think justifiably so, we can overcome any notion of fraud whatsoever by showing that Mr. Collie comported with what he's contended this entire time, which is number one, that obviously the earnest money was contributed. He was an authorized person on the Bayview mortgage and made payments directly to them. We have Mr. Hurd's deposition that says, I didn't even have any contact with Bayview because he was the sole authorized person to speak on that. Okay. And that we had multiple attempts. We have affidavits. We have the production of the loan documents to show a good faith comporting with the obligations. And that in and of itself, I believe, is dispositive that there's certainly no fraud. I think the crux here, as I'll address in a moment with your permission, is that the closing itself of the PSA was actually just the refinancing of the residual amount of money owed in the refinancing. That transaction and the crux of it was to obtain a limited warranty deed, the type of deed that a commercial real estate company would lend on, not a tenuous quitclaim deed. So my client is never of the position that there was any intent at the present time of transfer. And we have to let the entire transaction of events transpire so that we can look back to see that intent. The intent to comport under that PSA is the working with the lenders. It's the paying of the rents. It's the moving forward. He contracted Ganic PC to do the title report in February. We obviously have the loan approval. We have a third-party affidavit from the lender itself that says, hey, we're not just going to lend on a representation by a prospective borrower. Show me existentially the amount of money that we owe so that we can prepare a wire. It also states in the lease that any residual amount of money above and beyond what was owed to Bayview was to be kept by Mr. Collie. They had the purchase price set at $385, and Mr. Hurd's deposition unequivocally, without a doubt, confirms this, that there was the $96,000. There was the delivery of the quitclaim deed to Mr. Collie, because Mr. Hurd had no idea. He could have closed it 2 weeks from then, and then it would have been a non-issue. So provided the quitclaim deed, of course, with the anticipation of it being recorded, because we don't have anything to that effect. And Georgia law is clear that with physical delivery, the intent is to release dominion over that instrument. So we have that, right? So to that end, then we have the consideration of what's to be refinanced from Bayview. We have the loan approval, albeit 14 days before the end of the contract period, which is very much in dispute, because if we're going to talk about an integration clause, the PSA is integrated into the lease where it says that, Collie intends to close on the property by the end of the lease, which is March 31st, not February 28th. Even if the court does not accept that, we had this loan approval in advance of the 28th with an affidavit from the lender that said we would have closed in a matter of days had we received the payoff letter. Furthermore, as you probably reviewed, the payoff letter itself says notoriously and unambiguously acknowledged and accepted by, presupposing a signature, and it has the signature block there. That is the document provided to Bayview to authorize the payoff amount at whatever is stipulated within that. Mr. Collie, of course, told the lender, yes, here is the payoff letter of 172.5 to sort of pro forma justify the amount of money for which he was seeking approval. But furthermore, in that same vein, we needed that payoff letter with the signature, again, unambiguously stated that this is in full satisfaction, this amount. Once that's provided to Bayview, then they can accept the payment from the financing company who received confirmation of that payoff amount. So to sort of recap, we had the quitclaim deed that was transferred in exchange for the $96,000. They contend it was conditional. We contend that that was provided without any conditions whatsoever, because at that time it was the consideration for the equity. Also, Georgia law states that $1 of consideration in a deed effectuates the transfer. If we have parole evidence introduced to say that the consideration was different, Your Honor, then they have a right of action to seek enforcement of that contract price. That's exactly what we're trying to do here. Borrow the money, pay off the financing. Mr. Hurd says, quote, or excuse me, let me not quote, but I'll point to the page in line. The transaction was consummated once the mortgage was paid off and there was an offset of the $40K from the liens that Hurd was supposed to remove. This is in page 34, lines 12 through 25. Mr. Hurd admitted unequivocally that, hey, the $96,000 was received. Once the mortgage was paid off, that left the difference between the $40,000 owed by Mr. Collie and what comprised $28,000 in liens. Mr. Hurd admitted in his deposition that he could set off the liens from the $40,000 payment at closing. It was a condition precedent for Mr. Hurd to remove those liens. But he said, hey, I'll tell you what, if you set off the 28,000 from the 40, you just pay me 12, this thing's done. There's no other consideration. The only closing that even matters at this point is the closing as between the Bootery discharging the loan from Bayview, and then the grantor, well, in this case, we, in lieu of the quit claim, whether scrivener's affidavit or just a subsequent entitled limited warranty deed, would be provided at that closing, presumably by whom? Bayview, because Bayview has a security instrument filed on the mortgage itself. Mr. Collie also contended that Bayview may have had an issue with this quit claim filing, but never did. They never raised issue. So we had the quit claim, which was transferred and filed. Nothing happened on it. Then we move over to the PSA to to govern the transaction for the refinance and the 40,000 and 28,000 liens. That's how it incorporated the 96,000 as earnest money. And we have non-lawyers drawing this thing up. Then we get to the 11th hour. The approval is sent over. Hey, let's just go ahead and get this thing done. Just sign this letter right here. Plaintiff has never contended one time that just signing that letter wouldn't have effectuated it when it would have. They say it has no effect when the unambiguous words, we want to talk about integration in four corners, the integration of that language acknowledged and accepted, which would be Bayview's acceptance of the discharge of that debt for that figure.
So what is your version of events as to why the closing didn't happen? Mr. Kane has helped me understand that his view, his client's view, is Mr. Collie never really wanted a closing. In his mind, he didn't need a closing because he had rightful title to the property through the quitclaim deed. And the closing didn't happen. We do agree on that. No factual dispute there.
Right.
Why did it get derailed?
So based on the affidavits, documents, and depositions of the client, which sets the tone for this entire summary judgment under the uniform rules of Superior Court, okay? The financing was obtained and the approval was obtained. That in and of itself is dispositive of good faith. If he even got that conditional approval on the 27th or even the 28th day of February, that's dispositive of no fraud. However, he gets the conditional loan approval, calls, emails, and texts the contents of the same and receipt of the same to the plaintiff, Mr. Hurd, to come over, just sign the document. I can't imagine anybody not wanting someone to come over and sign a payoff letter for him. I mean, please come to my house, get my mortgage, sign a payoff letter, and go pay it off. You know, discharge city, all right? Be that as it may, there were the communications to the client. Had there been no obstruction, Hurd says in his deposition something to the effect, well, I needed to see the contract. Well, what contract? All the communication you just said you gave to Mr. Collie as between he and Bayview. Then as soon as the contract terminates, you reach out by admission and tell Bayview to stop talking to my client. He gets the letter from Bayview, gives it to you. You say you don't need to sign it. You say, well, plaintiff's attorney contends, well, why didn't he just give it to the Bootery? I could draw up I do transactional law. I could draft up a beautiful thing and take it to someone and be like, hey, I need to wire this over there. Thanks. Don't look any further to that. Absolutely. Okay. You need to put your signature on that form to relinquish and approve the discharge of that debt at that price. Furthermore, the Bootery needed that confirmation to proceed with its lending. Of course, there was no closing. The condition precedents that they needed to discharge that debt on behalf of Mr. Collie were completely and utterly frustrated. The concept of closing is very simple. Your Honor, you are well aware in Georgia, it's not required to have a closing. Lenders like to have it so that everybody is aware and can't come back after the fact making representations. Aha, an integration clause, right? But you don't need to effectuate the transfer of a deed. You need consideration. That was provided in the form of the $96,000. Whether or not that's factual dispute, fine. There's absolutely admissions up, down, and sideways that the 96 was accepted in exchange for a deed, okay? But the true closing was that to be effectuated by and through the financing company. No closing was necessary for the transfer of the quitclaim deed because the $96,000 wired in cash for a piece of property that has had subsequently $300,000 worth of improvements put into it. The conversion between an auto body garage and auto repair can be substantial, okay? To that end, now we have a guy at the 11th hour precluding keeping $96,000, keeping the improvements of the property, running up attorney's fees. We have a guy who puts in all these complaints about fraud up, down, and sideways. The word fraud's not even in the deposition, and then contends something about an integration clause to say that a completely different transaction was somehow after the fact integrated into a completely different document. We have to deny the motion. I mean, his motion was on fraud. By virtue of getting that loan approval, that shows the scienter of my client to show that there was no fraud intended at the present transfer between either the quitclaim deed or the execution of the PSA.
Hold on one second, Mr. Moore. So, Mr. Kane, you're on. You have two.
Hold on, I lost the audio. What are you doing?
Okay, so I can see you. There's one that says Daniel Kane and one that says Ms. Yazid. I've
Wait a
muted.
minute, I've lost, Judge, I lost the audio. Hold on.
I can hear you.
Thanks.
Okay.
I can see your ear. Can you hear us, Mr. Kane?
Okay, I'm back, Judge.
Yeah, that's not gonna
Turn
work.
off
You're,
one of the two accounts that you've got open.
yeah.
You're on twice.
Okay, can you shut the computer?
Okay, great. Now it's just one.
Okay. All right,
All right.
thank you, Your Honor. I didn't hear your question, so if you could repeat, please.
Well, the question was, you're on twice, and I needed to know which one you wanted to have on, because it was creating a funky
Echo.
feedback loop. But I can see you and hear you, and we'll shift back to Mr. Moore.
Okay, thank you, Your Honor. So I'd like to jump in at this time just to conclude that there's absolutely no merit, and I mean all this respectfully, of course, Your Honor, to the motion for summary judgment. We have a citation to a Hambrick v. Bedsole. That's a case about consideration, and that the relinquishment of some previously accepted consideration was relinquished for a modification agreement. The court had to determine whether that relinquishment of a prior right could serve as consideration for this modification agreement that was contended wasn't supported by consideration. I mean, you know, so let's take for granted that there's a deed that even exists in this arrangement. It was a brokerage deal. The case at bar here is total 1-2 party transaction. There's no brokerage. Mr. Collie wasn't holding it for a third party. There was no trust issue, nothing to that effect. They were saying that once there was a warranty deed that he could go in and then claim the property as payment of the brokerage fee for the land. And I got to be honest, I didn't find the applicability of that case to these facts. Ours are much more clear. And while he contends failure of consideration, we're contending that, number one, there was sufficient consideration for quitclaim. Alternatively, the failure of consideration was procured by plaintiff. Moving forward on McCravey v. McCravey. Okay, fraud and derecordation is the issue in that case, Your Honor. So let's just read a quick rule. Where the promise of the grantee in a deed was the consideration inducing the grantor to execute the deed, and where the grantee failed to comply with that promise, and where such promise was made with the present intention on the part of the grantee not to comply, okay, then the deed can be canceled. So in effect, distilled down for our YouTube audience, if you promise to do something in exchange for the other party's detriment, but you had no intention of doing that whatsoever, you don't get the benefit of that bargain. That was fraud. So the court says, analyzes and says, well, we need to look at what the intent was at the time these representations were made. Well, on these facts, we had a father that told one of three sons to whom got, a divided 1/3 interest in a property, hey, third son, the one who was defrauded, deed back to me. The other sons are deeding it back to you, and then I'll deed it back to you in my estate, and because I need to pledge it as security for some funds. Well, the other two sons were not required to send their two deeds back. The third son's case law was actually submitted or transferred then to the remaining two sons. Then beyond that, the grantee, which is the dad,
I don't know what's going on here.
never passed the deed back to the son as an heir. And that's how he discovered. He's like, oh, my dad passed away. I should be getting that 1/3 interest back. This is great. Nothing ever happened. They went back, looked at the facts and circumstances, having allowed the entire transaction to play out, and realized there was never an intention for him to deed this back. Just didn't happen. They concluded that was fraud. Here, entirely distinguished. Your Honor, again, just having the loan approval itself on February 21st is dispositive of a present intent. It may have been late in the contract. I'll even take that for granted. Okay, and we've discussed it at length. Well, what took so long? Well, sometimes getting financing for these things, the appraisal has to come through. You have to get these other reports, yada, yada. So it took some time for him to find somebody and got the approval. But when you rewind it all the way back, you can't say that he never intended. If he never attempted to get financing, if he never reached out to anybody, if I didn't have a loan approval, if I didn't have any of that, there might be maybe a present intention not to comply, but even still, they would have to prove that with facts, citations to authority, and evidence in the record, none of which exists. I'm not asking or requiring that, that the plaintiff's attorney prove the 4 elements of fraud, but we certainly can't go back and impute some intention to defraud, considering he provided $96,000 to Mr. Hurd. So those comprise a present intention to actually comport in good faith, eviscerates fraud. Moving forward, on Shoemake v. Williams, okay, this is on the issue of fraud. Where the
These cases that you're citing are cases that you are seeking to distinguish. You're saying they were cited by Mr. Kane, or these are cases that
Correct.
you are presenting that you think rebut Mr. Kane's claims?
These are Mr. Kane's cases parsed out from his brief, and I am distinguishing the facts at bar from the case law that he's provided that he says speaks to these issues. The proposition.
I'm comfortable playing that role when the time comes. I thought you were transitioning now to presenting the arguments you wanted to present for your motion, but I may have misunderstood what you were saying.
I'm happy to pivot to that. I just my overarching point in discussing some of the case law, Your Honor, and I apologize for us not being on the same page there, was to show that the plaintiff has pled fraud completely, unequivocally, and I think exclusively. And that these cases require a showing of a present intention not to operate in good faith or not to comport with the grantee's promise, which is that he would go get this refinanced. We have affidavits, we have loan approvals, we have all of that. So I don't have to go through that and brief that again, Your Honor. Now to pivot to my motion, if we are there, which I'm happy to do, of course, I am contending really only, Your Honor, that the closing never occurred and that was a procurement and an obstruction by the plaintiff. I think it's abundantly clear in the affidavits provided by not only the lender, but Mr. Collie, the admissions in Mr. Hurd's deposition, and in Mr. Collie's deposition, that there was no desire, and we're not pleading fraud, and I'm not putting that before the court right now, but I query whether there was an intent on Mr. Hurd to ever close the property. I think once it started getting closer to the finish line of this of this transaction period, if you will, that here is a piece of property that's had the benefit of aggregating in value, that has been improved, admittedly. The extent to which is, of course, maybe perhaps for another day. But that $96,000 had already been earned, presumably spent. And that, hey, if I just maybe not check my phone, or I don't know what he's up to, so I'm not going to explore that, or I didn't have any contact with Bayview because I wasn't allowed to when I made you the authorized person. And that's your argument that my client didn't close when I have a loan approval. I've got an affidavit from a lender that says that's all we needed. That's it. We had the rest of it. There's no integration clause argument. No way. No way. This comes down to, we had an offer for performance, which was impliedly refused by the failure to sign the document, expressly refused, admitted in the deposition that it was never signed, that he wasn't going to sign it, on some condition that he needed to see some contract that he wasn't a part of, and needed to do nothing more than sign this payoff letter by its express terms, thereby discharging that debt. And the closing would have happened. I contend that the true expiration date of this entire transaction would have been March 31, at which point I've got a second payoff letter because the first one expired. Like, hey, maybe give you the benefit of the doubt the first time you didn't get it. Sorry about that. We couldn't connect. Things were muddled. Here's the second one on March 4th.
Is there language in the purchase and sale agreement about the party's obligation to put forth good faith or best efforts to perform?
Yes, Your Honor. Absolutely. In fact, 3CI, if my memory serves me correct, I have not actually looked at that. I'm going to switch, so I'm going to go off screen for just a brief moment and pull up.
Sure, me too.
My purchase and sale agreement. There was unequivocally that, and it was put before the court as well.
Yeah, duty to cooperate is 3C. It's all in 3C. 3C3. I'll make sure I'm saying this the right way. C. So C3.
Yes.
C3. And Mr. Kane had pointed us to C as in Charlie. C3C, that's the integration clause. C3I is an agreement to do all things reasonably necessary to timely and in good faith fulfill the terms of this agreement.
Which is certifications, affidavits, and statements required by law or reasonably requested by the closing attorney, mortgage lender, and or the title insurance company to meet their respective requirements. I portend that this is very much, if not, it feels like an affidavit. Whether or not it has a notary stamp on it, I don't think matters. But it's certainly an affidavit that says, yeah, 172.5 and this is discharged. Yes, I accept. We have the complete refusal. Your Honor, I lost you.
I'm here.
Are you? Okay. Hold on. There you are. All right, sorry. Yeah, so we have, you could encapsulate the purpose of that document, I think, in any one of those, one of those items. I think mortgage lender, that incorporates both. It doesn't say for purchaser, for seller. To that end, we'd have to presume by the four corners of the document. Again, this is an integration. Didn't comport with it. Flat out. Flat out. And obviously, again, I don't need to brief the court on the case law that's been well settled for, a number of years on obstructed performance.
Right.
But I have briefed the court on the same.
Okay. Mr. Kane, I appreciate you've been trying to work through some technical difficulties. I actually don't see you now. I see some nice artwork.
Good, that's my office.
Excellent. I don't need to see you. I don't mind seeing you. But
Are you
as
saying
long
are you
as
saying you've seen enough of me?
that happened many years ago. So, but I do want to give you an opportunity, just like Mr. Moore had an opportunity to rebut what you had to say about your motion. He's now said what he had to say about his motion, and I want to give you a chance to weigh in whatever way you want. So, you're on Ms. Yazid's feed. It's audio only right now, which is perfectly acceptable for me, as long as you know, as far as I can tell, it's audio only.
Yes, sir. It is audio only.
Okay. So
Okay,
thoughts, comments?
I'll say a couple things.
Okay.
First of all, respectfully, Collie is taking two positions, metaphorically speaking, out of both sides of his mouth. The factual issues the council raises, we maintain, are inaccurate. So you got factual disputes here, like would Hurd cooperate? Hurd said he would cooperate at a closing. Would Hurd sign the Bayview letter? Hurd said he would do that at a closing. Would Hurd go to a closing? Hurd said he would go to a closing. Collie never scheduled it. So the fundamental issue that I maintain to the court for summary judgment, you asked pretty specifically, was the $96,000 that you maintain was to be considered to purchase the property? That's what they argue to you today. Is any of that in a written agreement? And the answer was no. So all of this is just talk. It's just smoke. It's just mirrors. You've got a contract. If you read the contract, this isn't in the contract. It doesn't say that Collie pays $96,000 to get the property. Contract says very clearly, you pay $96,000, it's non-refundable, and you have an obligation to close on a date certain. So you can't change that. And that's what I submit to the court. If the court follows the integration clause, the court will apply. The court is to simply enforce the contract according to its clear terms, and the contract alone is looked at for its meaning. All this other stuff is talk. It's a way to try and get the property for 96 grand and breach the contract. But we submit to the court that if the court reads the contract, follows the law, it's a legal decision, the court will rule that the quitclaim deed was not supported by consideration. It is not within the four corners of the contract. The $96,000 that they say was the consideration is not within the contract. The $96,000 within the contract says it's a non-refundable earnest money on a payment of $385,000. That's what the contract says. None of this, absolutely zero of this argument is in the contract or is supported by any memorandum or email or text message or anything. It's not there. So we submit to the court that the court should set aside the quitclaim deed. Collie stated very clearly, again, I don't want to beat a dead horse, that no closing was necessary. So how do they argue to you here today that Hurd obstructed a closing? You know, it just doesn't make any sense. So what doesn't make good sense doesn't make good law, and we'd ask the court to deny the specific performance, grant a summary judgment, be done with this case. Thank you.
You're welcome. Mr. Moore, anything else you want to add? I know you disagree with what Mr. Kane had to say, but I think he was putting the ribbon on the package that he had been delivering today. And it was responsive to some of what you had been presenting in connection with your motion for summary judgment.
That's correct, Your Honor. Obviously, we just pulled up the contract and saw some principles. There was no requirement that there be some official, time and place and manner and all of that, and that a full tender under Georgia law doesn't have to be a physical remittance of cash, but the offer to perform. That's exactly what we had here, Your Honor. We had the offer to perform. Sign this letter, prove the discharge. You're absolved of any further contractual liability with respect to Bayview. To think that there is no other detriment to Mr. Collie is, I mean, I can't even comment on that other than he's assuming the mortgage. Whether or not Mr. Hurd had it encumbered is not of any fault of Mr. Collie. That is what it is. He had to go obtain the financing, which is a detriment to Mr. Collie, to the tune of, we saw the document, $192,000+, which now presumably, with the grace of the court, to the extent that this is found in our favor, which I believe is entirely dispositive of, is going to have to increase above that to the extent we're not awarded attorney's fees. There's a huge detriment here, and there's a tremendous amount of contractual obligation that was skirted for the convenience of trying to appropriate the property back to the plaintiff. I couldn't, from an objective perspective, it is so abundantly clear what's happened here. And with that, Your Honor, I request that the court grant my entire motion, reject the entire motion of plaintiff. There's been no contention of fraud. We haven't even heard anything about fraud, and it's not contained even in Hurd's deposition one single time. And I ask you to go back and look at that. And with that, I do request that we get payment of our attorney's fees, which are aggregating on a minute by minute basis. And with that, Your Honor, I conclude.
Okay, I don't want to aggregate them much more, but I do have one question. If I were to go to 934 Metropolitan Avenue or Parkway today, which I won't, what would I find there, and who would be in the building?
Mr. Collie.
So Mr. Collie is still there?
No, I'm sorry. He might be in the courtroom.
Well, I know he's here, and I just waved to him, and he nodded back. But it is his place of business, right? I say his. He is occupying it right now.
He is occupying it. He has 6 employees. He has everything that he needs to occupy a lawful and, frankly, a profitable business, improved and conformed and retrofit to the purposes intended.
So, is there still an outstanding mortgage on the property?
Yes.
And is it being paid?
I don't know, to my knowledge. I believe that Mr. Collie, there's been a cessation of communication as between Mr. Collie and Bayview where it was otherwise authorized. So as soon as the plaintiff purported or portended that this agreement expired, they removed his ability. He's maintained possession under advice of counsel while we resolve this because of our contentions before the court. But I believe he is sending money there so that it doesn't get foreclosed. But if he has been prevented or precluded from payment, I don't believe that he can be held responsible for the damage that flows from there.
Okay, I wasn't trying to create new legal issues.
Correct, and I believe the mortgage is actually current.
Okay,
yes.
Okay, Mr. Kane, this doesn't resolve anything. I'm just curious. Is as far as you know, is the mortgage current?
We don't know. We know that in the lease, that the lessee was responsible to pay the rent as mortgage. We understand he's done that periodically. We don't know if it's current today. We do know that he's been doing that. And also, just so the court knows, the lease has expired and we have given notice to vacate the property, which Mr. Collie has ignored.
We have received that, Your Honor.
Okay, when did the lease expire?
Let me get you the date.
Well, there's actually a matter of fact as to that, Your Honor, as you can imagine, right? The expiration date on the second lease was March 31/19. However, they didn't follow proper protocol in terminating that lease, at which point it went to holdover and they had to effectuate the 60 days notice, which we didn't receive until a pretty exorbitant amount of time after that. So honestly, I think it's a matter of fact. Yeah, actually a matter of law as to when that expired.
Well, okay. And
so let me answer the court's question. The lease expired. It's a May 17, 2017 lease, and it expired by the 4 corners of the lease on March 31st, 2019.
Okay. So the lease is expired. It may well be then that Mr. Collie, it had become month to month, tenancy at will, whatever the right term is, not my area of law. And there may have been certain provisions by which Mr. Hurd ought to have given notice to Mr. Collie, whether they were complied with later in time or not. It does sound like they were ultimately complied with, and there could be another pending issue of Mr. Collie needing to get out of there. So that gives some urgency to working through this. Is there going to be an emergency motion coming my way, or can we maintain the status quo while we work through this?
Sir, we've we included in the complaint that he should vacate the premises due to the expiration of the lease, and we think that the court's ruling ultimately will be dispositive. If the court agrees with plaintiff, then he's going to have to get out.
Okay, so, I follow that, and I am aware that that's one of the claims in the complaint, but it may well be that Mr. Hurd is pursuing alternate channels to regain possession of the property, and I don't want to create a cross-court conflict, because in magistrate there's a dispossessory action, and we've got this here. And that's why I'm asking, is that do we have an understanding that the status quo will be maintained, or is that something that would be the subject, not today, but some other day soon, that we would need to work through?
We have an understanding that the status quo will be maintained unless we notify the court otherwise. The court's calendar is moving very quickly, and I believe this is now for a bench trial. So we're moving even quicker. Great.
Well, we'll try to keep pace with events as they unfold, but please do, whether it is Mr. Kane on behalf of Mr. Hurd or Mr. Moore on behalf of Mr. Collie, keep Ms. Niles posted. You know, there's a third actor in the mix, and that would be the mortgage lender, and they could take a step. And it sounds like the channels of communication are a little fractured. Mr. Collie occupies it, but he now isn't able to communicate directly with Bayview. And if Bayview suddenly asserts itself by way of foreclosure action, that's another wrinkle that we'd want to work through, because it might be that Mr. Collie's in a position to ward off the foreclosure. It might be that Mr. Hurd doesn't mind if the foreclosure goes forward. I don't know, but I'm going to rely on the two of you to keep Ms. Niles posted if either side is trying to change the status quo.
Yes, sir. Understood.
Mr. Moore?
Acknowledged and agreed. Thank
Great.
you, Your Honor.
Okay. Anything else, Mr. Kane, before we let Ms. Kale go offline?
Nothing further, Your Honor.
Mr. Moore?
With that, I request to be excused.
All right, you are all excused. Ms. Kale, I need you to contact Ms. Niles. And so you two should stay on the phone so you can get Ms. Niles' email address, because we're going to need to figure out how to get you the record. It's still recording. I'm going to stop it in just a minute, okay?
Sounds great. Thank you.
All right, thanks, everyone.
Thank you,
Thank
sir.
you, Your Honor. Be safe.